Hello, everyone. Hope you're all doing well. UCS is back again with another podcast, and today we have with us our chief trainer, Miss Anupama V, who is an expert on PoSH and is also a very successful corporate lawyer. Hi, Anupama. How are you?
Hi Kaveri, I'm doing good and it's great to be back again.
Well, Anupama, I have a question for you. When an inquiry under PoSH is on the request of the respondent, can the IC allow the respondent to cross examine the complainant and the witnesses in the case?
Kaveri, it is not can, in fact, it is mandatory because an internal committee has been given the powers of a civil court and following principles of natural justice as per our constitution is mandatory.
When such a request is made, how should the IC go about in allowing the cross examination by the respondent or the complainant and the witnesses?
Well, it's a very subjective question, Kaveri. Um, while I said that it is mandatory for the IC to permit a respondent and the complainant to cross examine each other or their witnesses, how the IC goes about it is left to the discretion of the internal committee. Now, the reason why I make this statement is because often the cases that come before the internal committee can vary. You might have a situation which is a very grave case of sexual harassment where the mental stability of the complainant, or it could be a false complaint that has come and there is the mental stability of the respondent that is involved. We do not know what the situation is. Now, given the situation on hand, it is at the discretion of the internal committee to take a call on whether it would like the complainant, the respondent to cross examine each other or their witnesses, either asking them to submit written questions for cross examination or asking them to do a verbal cross examination of each other. Now, how does, say, for example, if someone asks you, how do you decide that? I would say when the allegations are not very serious in nature, when there is no strong emotions involved between the respondent and the complainant, then it would be absolutely fine to permit them to do a verbal cross examination. But if we do think that the situation would only aggravate with both of them asking questions to each other, then it's a good idea to ask them to submit written questions and the IC can ask the respective persons to reply. Now, here we come to the next question. What if either of the parties, based on the written questions they've submitted, feel that they could have asked more questions depending on the replies given by the complainant or the respondent, as the case may be, when written questions are submitted to the internal committee and the internal committee has asked those questions? In such cases, it's absolutely fine for the internal committee to give the reply given by the complainant or the respondent or the witnesses, as the case may be, to the concerned party and ask them if they want to ask additional questions. As I said, it's very subjective. There is no black and white answer to the situation. However, cross examination has to be permitted, that is mandatory. How you go about it is left to the discretion of the internal committee.
Thank you so much, Anupama, for sharing your knowledge with us. Ladies and gentlemen, I hope you found this episode very informative and interesting. Do get in touch with us with your queries, suggestions, and feedback by emailing us at admin@upceedconsulting.com or writing to us on LinkedIn, Twitter, Instagram, or Facebook. We will be back soon with another interesting topic. Wishing you all a great day ahead.